Hey, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, will be before the Commonwealth. Draw near, give attendance, and you shall be heard. I sit the Commonwealth and Justice, close open, please be seated.
Good morning. Welcome. That works. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Brennan. To my left, Justice Wood. We will be hearing one case today. It is an impounded case, so I should remind everyone to use pseudonyms for the parties' names, mother, child, and so forth. I gather there will be division of time on the appellee's side, with Attorney Cuttle speaking for 8 minutes and then Attorney Goldberg speaking for 7 minutes. Is that correct? Very good. We will hear, well, I guess I should call the case. It's number 25424, Department of Children and Families versus Mother. And we will hear first from Attorney Chayette.
Thank you very much. Good morning. Kara Chayette for the mother appellant. I plan to touch on all three issues today, the mother's competency, the lack of counsel, and what happened on the day of trial, because even viewed in isolation, they each require a remand for a new trial. So to be clear, I'm not challenging the determination that the mother was incompetent, but the process by which that determination was made and everything that flowed from it just epitomizes the irregularities that plagued
You mean
the
that
case.
she was unfit? You said competent.
Oh, incompetent.
Where is there a finding that she's incompetent?
Well, that's just part of the problem. So there's no competency evaluation, there's no hearing, no judge uttered those magic words.
So
I find the
don't
mother
understand. So
incompetent.
what do you mean when you say you're not challenging the finding she was incompetent if there wasn't one?
Because we know that she was, in fact, inferred or presumed to be incompetent because three reasons. A GAL was appointed to her. The request for the GAL was couched in terms of her competency by mother's counsel and child, seconded by child's counsel with DCF's acquiescence, transcripts 5 to 6. It's a very brief sidebar. And 3, the only kind of GAL that can be appointed to a parent in a CMP is a GAL for diminished capacity. So why does it matter if I'm not challenging that determination? Well, for 2 reasons. Because a GAL for diminished capacity operates in a substituted judgment capacity, and that divests a client of agency. The GAL stands in the client's shoes, is her voice, and we shouldn't be divesting people of agency so haphazardly.
Sorry, are you saying, I'm having a hard time following, are you saying that the appointment of a GAL for diminished capacity, you're opposing the appointment of a GAL for diminished capacity?
No, the problem is that the GAL had no idea what she was supposed to do, and in her defense, neither did anyone else.
How can they?
Sorry,
Well, go ahead.
no, the GAL who was actually appointed, the legal advisor, the lawyer.
She was appointed at various times legal advisor, diminished capacity evaluator.
I understand the point, or I understand what you're saying, but we're talking about the same person, the person who was a lawyer.
Yes.
Right,
yes.
okay, that's what you're talking about.
That's
Go ahead,
right.
go ahead.
But so at various times, people say she's pursuing the mother's best interest. No, she's doing substituted judgment. No, she's the competency evaluator. No, she's a court evaluator.
Okay, so let me ask you a couple questions about this, because I don't know the ins and outs of this in a DCF case. I know a little about it in a criminal case.
I can only
I'm
just...
sorry, yeah, I don't know what the...
There we go.
Does that work? Is that any better? I don't know. So I know about this a little in the criminal context, but I've never seen it in a DCF case, or at least no contest about it. Let's say the lawyer had more clearly said, I think she may be incompetent, Your Honor. We need a competency hearing or evaluation or something. You think the judge can appoint a GAL to do that?
To evaluate the
To
mother's
evaluate her
competency?
for competency such that a substituted judgment GAL can be put in place. Like, I don't understand, without a finding of competency, and I don't see one here, I don't understand, I mean, if it just looks to me like the judge, no one in the room had any idea what a GAL can or can't do, and certainly didn't know what these 3 categories were. And even when they checked the categories, they still didn't know what they were, particularly since the one they keep checking is for children. So they obviously don't know what's going on in some sense. It seems clear that there are serious questions about the competency of this woman. I don't know if they require sua sponte action or they don't. The doctors didn't believe she could consent to an epidural during childbirth. She must be in, at least by their judgment, quite, seriously compromised condition. And then it turns out a court has found her incompetent, although we have no records about that. No one's put in an affidavit, nothing. So I don't even know what it means necessarily. I don't even know that it's a criminal case, I think.
It was.
How do we know that?
I think that the first trial counsel says that it's Worcester District Court.
District Court hears civil cases?
No, criminal cases, and I mean, you can go on mass courts and you can.
There are no civil cases in district court when they're under $10,000 or something?
No, you're absolutely right. There are civil cases in district court, but in fact, hers was a criminal case.
How do you know that?
I believe.
Is it in the record?
No, I'm not. I think
Okay.
they just said district court, and I just happened to go on mass court, so that's how I know.
Okay, so.
Yeah, I think I don't
So,
know.
okay, so maybe the judge should have done it sua sponte, or maybe that's what the lawyer was really asking for. I have no idea. But what should a judge do? Let's say confronted with substantial reason to believe the person is incompetent, and a motion for a competency hearing or something. What does the judge do? Do they appoint a GAL, or what do they do?
What should happen is that the individual is evaluated by the court clinicians, and then there's a hearing to decide.
Is there a statute that explains that to me?
I think that's just ordinary practice in courts, that you have that the court clinicians are available for these kinds of evaluations, and then there's a hearing.
Is
But
that's for parties as well? I mean, I'm not sure that that's the case, that the clinician necessarily in a juvenile court is available for a parent who's.
And again, this is something that, I mean, I know from
Right.
one of my prior CNPs that this happened for a parent in Springfield Juvenile Court. But that is.
I'm not saying a judge couldn't say, could we bring the clinician up and have, but I'm not sure that's in their job description, nor part of any statutory requirement.
Well, but of course, so then there would have to be somebody that was brought in, but I think the thing is that Kirk doesn't answer the questions in these cases, but Kirk did say that if there's a request for a competency hearing, or there's substantial reason to doubt the parent's competency, that the judge sua sponte should have an evaluation and a hearing.
How does the judge arrive at that conclusion if the person never appears in court, and if there's no motion? So obviously, if the person's there, a judge can take a look and get a feel and say, this is something amiss, let's get this person evaluated. But absent the person being before the judge on with enough time to make that assessment, isn't it incumbent upon the attorney or someone else to say, hey, we need to do this?
Well, so she moved for the appointment of the GAL, and I guess,
Right.
and I understand. I mean, there's a little bit, we're sort of battling in the ether because none of the proper procedures were done. But we have, and I guess one thing, Justice Rubin, at the April, so everyone sort of says there's a competency issue. In August of 2023, Judge Dunbar says, we really don't have an answer about competency. In April 2024, Judge says, it seems very much like she's acting in a diminished capacity. That's the closest we get to a finding. But I
Excuse me,
think
there is an appointment, right, as an advisor in diminished capacity on June 28th, 2023. I'm looking at
that's right.
Record Appendix 26, and there is an appointment, and it checks those two boxes.
And then, that's right.
And what do we make of that?
Well, but that's what I'm saying is, so none of those other appointments were appropriate. The only one that was appropriate was for diminished capacity. And so now I'm sort of trying to say, where do we go from there?
But
Now-
wait, the person who was actually appointed, I'm aware of the box, the form and the two boxes. The person who was actually appointed was a lawyer, not a mental health professional, right?
That's right.
So that's an important point that we need to stop and understand, right? That there, notwithstanding a box was checked, there never was a diminished capacity mental health professional appointed as a GAL for the mother, right?
Right.
Okay.
That's right.
And I assume, although I don't know, how can you appoint someone to do substituted judgment for someone who hasn't been found incompetent? I don't see how you do that. Now, maybe the judge implicitly was finding her incompetent. Based on what?
But that's exactly part of the problem, Justice Rubin.
No, I understand, but I'm trying to figure out what you're complaining about exactly.
But back up, that's the third step. Correct me if I'm wrong. I'm no expert here, but I think that a GAL of this skill set, which this GAL was not, she was a lawyer, the GAL of this skill set, the first thing they're supposed to do is talk to the lawyer who's appointed to represent her and figure out what her capacity is, and then talk about accommodations to help her work with her lawyer. You don't jump to substitute judgment and figure out whether the substitute judgment is necessary. You do it. You assess her whether she needs accommodations and whether that can help her work with her lawyer. Right?
Maybe so, although I want to make one point. There is no case law that discusses what the function is of a GAL for diminished capacity for incompetent parents in CNPs. But there is case law about the function of a GAL appointed to an incapacitated person in probate court proceedings. And the case law is very clear that those people operate on a best interest capacity.
Okay,
And
it's not remotely clear, right? Because there's an
understand that, but
MUPC that's been adopted that.
Absolutely.
Okay.
But that's part of why it's so important that this be clarified here, because the GAL at the August 2023 hearing said, by the way, Judge, a GAL was appointed to this mother in the probate court. I thought I was doing what she does. And
May I ask you a question about that?
Yeah.
Because I'm not aware that there are mental health professionals available to the juvenile court on some sort of a list to be brought in and just appointed to folks who have diminished capacity. Are you aware of, in your practice, have you ever seen any?
I'm not, but I don't see how.
I know the guidelines say that they're supposed to do it, but.
But I'm not sure that that's a question that the court needs to answer, because it's really all of that run-up, how this happened, by inference, by presumption, which is so offensive to you, Justice Rubin, I understand it, but it's the circumstances we have.
Okay, but what I'm asking you, I think, is this. Let's say we agree with you and we haven't talked about it and I haven't decided yet and I don't know what we're going to do and we haven't heard from the other side. Let's say we agree with you, my gosh, this looks like a person who very well might be incompetent. We vacate the judgment and remand for what? What exactly procedure do you want them to follow on remand? Because we would have to give guidance to the lower court. Do you have a proposed procedure?
A competency and evaluation.
Stop. An evaluation, not a hearing?
An evaluation that will inform the hearing.
All right. The evaluation will be undertaken by whom?
I believe it's my understanding that it would be by the court clinicians.
Okay. And tell me what an evaluator GAL does.
Oh, no, not an evaluated GAL. An evaluated GAL is reporting to the court about the circumstances of the parties. That's not, there's a GAL for diminished capacity, which is different than a GAL evaluator.
I fully agree with you, but a GAL for diminished capacity is not, in my view, maybe it's a question of steps. I don't know why we're getting to that until we know she has diminished capacity. So I think the first step is figuring out whether she's competent, and I suppose whether, if competent, she has diminished capacity. I don't know what the difference is, but I would think that would be the first step. I'm not sure why you're saying it shouldn't be a court evaluator. The judge ultimately has to answer the question, is this person competent or not? So, I mean, there are statutes, I think in the criminal context, where people are sent to Bridgewater for some number of days to be examined, but there's nothing like that for a parent in a DCF case.
Right, but can I, there's an important difference. I think that I want to ask a question. My question is, when this is, let's say this is remanded, she needs a lawyer, right? Yes?
Yes.
Okay, and so this lawyer needs to be involved in deciding whatever there is going to happen next. Is it fair to say that the ultimate question here, this is not a criminal case, so the ultimate question is not whether she's going to have her liberty restrained. The ultimate question is what's in the best interest of the child, right? And so if you have a competency evaluation of a parent and they're found incompetent, isn't that very bad for her case in terms of being able to have her rights terminated in the best interest of the child. And if we agreed about that, isn't it crucial that the lawyer be involved in this train before this train gets all the way to she's incompetent? In other words, isn't it up to the lawyer to make that really important decision?
Well, but of course, the lawyer did, the first lawyer did by asking for the appointment of a GAL for diminished capacity.
Right, but that's, and that's where I didn't have a chance to jump in. I disagreed with you right at the very beginning that was, I took you to be saying that was a finding of incompetence.
No.
Okay, well, so so a GAL, I want to make sure I understand this because I think it's different than what Justice Rubin was characterizing it as. In this context, a GAL for diminished capacity is requested by the lawyer to assist the lawyer for the parent. It is not an evaluator who is assisting the court, right?
That's right.
And so it's this GAL for diminished capacity is serving the best interest of is working with the lawyer, is advising the lawyer for the parent, consistent with the ethical obligation of the lawyer to serve the best interest of the parent?
To serve the interests, the desires of the parent, not the best interests of the parent. So to pursue, and so just I think there's a little bit embedded in your question, sort of, if she's incompetent, is she not unfit? Is a little bit of what I heard, a little bit you asking?
Right. If
And that's not right. It's not necessarily the case. People can be in jail for murder and still have a relationship with their
But
parent.
it's not helpful.
But it's still there are lots of paths to maintain a legal relationship with your child, even if you don't have custody.
Fair enough. My point was simply, shouldn't the lawyer be the one be involved in that decision?
Absolutely, and
Right.
of course, there's the fact that she was stripped of it. She didn't have a lawyer for
Can I
12
know we're
months
over
of
time.
the
Can I
18.
ask you
You
about
can
that?
actually,
Yes.
I'm going to this seems really complicated, so I'm going to let this go,
Okay.
and we'll give the other side more time.
So my initial impression, having dealt with it mostly in the criminal context, is when the judge essentially struck the lawyer or allowed the lawyer to withdraw without the mother being there, wrong, can't do that. You never see him, you wouldn't do that, wouldn't allow a lawyer to withdraw unless the defendant was physically present. Then I came upon this case, Valentina, 97 Mass Appeals, 130th 2020 case that says the parent has to make an appearance to be entitled to appointed counsel, and counsel's appearance may be stricken if the parent repeatedly fails to communicate with either DCF or counsel, which is what counsel represented here. So it seems to me that the judge did not err or abuse discretion, and the lawyer did not do anything wrong by saying, hey, this person's just not communicating with me, I can't really work with this person, I'd like to withdraw, and the judge saying, okay, on that basis, you're permitted to do that.
That finding is not founded in the evidence. If you look at the transcript and look at what the motion said, both motions to withdraw said, mother has directed me to withdraw. It wasn't, I haven't been in touch with her. And if you look at the DCF record, not perfect attendance, not perfect communication, but she was in contact. She didn't abandon either her lawyer based on what the lawyer said. So that's improper, and I agree with everything that you just said about you don't do it because you can't determine that they really want the lawyer to withdraw, and you can't determine if they're trying to waive counsel, if they're able to do that. But you get even if you reject my argument about whether a judge can just pull out of thin air a doubt about indigence, the fact is that, I do come back to this incompetence issue, that she had a GAL because, right or wrong, she was presumed incompetent, and the rules require appointment of counsel for those people, even in the absence of a, indigent person. And she was psychiatrically hospitalized for a couple of months, and those people
Can I just ask again, when you say the rules, can you point to a specific rule that says that a parent is entitled to this process?
Well, SJC 3.10 says justice requires, that it's sort of in the discretion of the judge, but justice requires the appointment of counsel for incompetent parties regardless of indigence. And that's in the addendum.
Requires appointment of counsel.
Yeah, or the appointment of successor counsel.
No, I thought we were talking about, okay.
If you're going to allow that motion to withdraw, which happened in August 23 and January 24,
Right.
then there's got to be successor counsel appointed.
Okay, I think we understand the issues with the withdrawal of the lawyer, and I think, although we haven't talked about them, we understand the issues of the judge knowing that someone told her to go to Springfield and then she shows up after the trial. Those seem like clear-cut facts, at least, that we can sort through and what the rules are seem roughly at least findable. I'm still stuck on this beginning thing, partly because opposing counsel says all of these claims are waived. So I need to understand, and I guess I still don't. You think the lawyer was simply saying, instead of saying, I move that she be found incompetent, that he was literally saying, she's incompetent, appoint a GAL to assist me. You think he was asking knowledgeably for a diminished capacity GAL who would assist him in communicating and at some point maybe use substituted judgment. That's what you think happened?
Yes, and there is one point I want to make about the day of trial once I answer your question, if you'll permit me. But
sure, of course.
in DCF's motion in response to the GAL's motion for clarification said, and I quoted it in my reply brief, it's like, the mother was asking for this, asked for somebody to evaluate the mother's competency. She didn't use those words, but that's what DCF's understanding of the sidebar was. And that motion is in the appendix. I don't have that.
That
paper,
is,
but it's quoted
you're
in the
saying
reply.
it isn't waived because that was a request for a competency evaluation, ill-articulated as it was, or focusing on GALs instead of court clinicians or whatever, but that it was a request. There's a question of her competency. It has to be evaluated or assessed.
Well, it's that how would this information be preserved? Yes, we hold pro se competent litigants to basically the same rules of preservation as we do lawyers. But I can't get away from the fact that she was treated as if she was incompetent. An incompetent pro se litigant can't preserve an issue. And since the facts that we're arguing about are on the record, I wouldn't go back with a 60B because that's to expand the record. A 60B doesn't preserve already unpreserved errors. It doesn't revive.
No, a judge doesn't have to hear on a 60B motion something you could have but didn't raise. No.
But it's sort of, I'm not sure how is this going to, we have a GAL who's sitting sort of paralyzed into inaction because she doesn't know what she's supposed to do. The mom is unrepresented for 12 of the 18 months of the case. How would these issues be preserved? And I think there's really good case law to protect it.
All right, yes.
One point
about the last day, if you like, and then
and I think you understood it, but in Hampton County cases, Springfield cases, are routinely or always tried in Holyoke. The transcripts bear this out. The judge knows that the mom's not there. Eartha and Titus are two unpublished decisions that are cited in my brief and included in the addendum. Those are basically the same facts. Mom took the wrong exit on her way to court. She'd never driven, doesn't arrive. And the other one, father and his lawyer get the time wrong. They don't arrive. Both cases are remanded for a new trial without assessing the sufficiency of the evidence. When rough justice rather than due process is the guiding principle, we don't weigh the sufficiency of the evidence. And with that, I know I'm well over my time. If there's something else that you'd like to hear.
Thank you very much. Very helpful. And we will hear next from Attorney Cuttle.
I believe it's afternoon. I'm not certain, but good afternoon, Your Honors. William Cuttle for the Department of Children and Families. Before I know you're going to have questions about the GAL and about the indigency issue. I just want to point out, because I was preparing for this argument, and there's a lot of speculation that Mother puts forth in her brief, and Mother is clearly trying to argue that there's a legal error here to avoid the prejudicial arm, since there was so much unfitness here. But the real facts are that the trial judge tried from the outset of this case to preserve Mother's rights. Mother filed a motion to represent herself at the beginning of the case. The judge denied that. Mother wasn't...
On what ground?
She denied it, wouldn't let her represent herself.
Okay, well, she has a constitutional right to represent herself, so on what ground did the judge deny it? Was it that she was incompetent?
No, it wasn't that, Your Honor. I don't remember exactly. I'll let the record speak for itself, but it was not
Okay.
that.
All right.
Mr. Cuttle, what do we do with a situation, which I'll just speak for myself, if I can't articulate precisely at what stage it was, because it was a respectfully, a bit of a mess at various points. Something was amiss here. You have someone who's got significant or clear mental health issues
Yes.
that may or may not border on competency, and I know that competency in this context is different from in a criminal court, but putting that aside, who's not communicating terribly well with DCF or with the lawyer, so then she doesn't have a lawyer, and then she shows up late or doesn't show up, and it just seems to me that fundamentally there's something amiss with depriving someone permanently of their parental rights under these circumstances, even if I can't put my finger on it exactly at the moment. Can you help me out with that a little bit?
I understand what you're saying. I believe that if you take a look at the facts, the judge's decision can look harsh at the end, but I just remind this court, and I reminded myself in preparing for this argument today, the judge was in the best position to make the decisions that were before her, and she did not abuse her discretion.
Well, can I start backwards then? Let's start at the very end. The judge says, so the judge knows and acknowledges that this woman was told the day before when she actually came to court to try to go to this very trial.
Yes.
That she...
No, let's back, Your Honor, I don't mean to interrupt you, but just, I don't think you can presume that. I think what we
Okay,
have
well,
to
she was
realize-
at the court the day before.
She went to the court, and she was
And
given
she
a notice.
may have been told, the judge says, I think may is what the judge says, to go to Springfield.
Yes, I saw that.
Now, leaving aside what federal court says about mistaken information given by court personnel to litigants, if she doesn't show up for trial because someone who works for the court told her something that implies going someplace else, and then she shows up 9 minutes late after the thing, shouldn't there be a trial where she's present? That is, how can you do this in absentia trial if she is in absentia because the court itself directed her elsewhere?
Well, I hear what you're saying. I think with all due respect, Judge Rubin, you're presuming that she was directed elsewhere.
Okay,
It's not clear about
what
that.
should why would I presume the opposite when the judge says it may have happened?
I don't think you have to presume the opposite, and I understand this is a difficult issue. I do. But if you could just let me answer your question.
Yes, I'm sorry I interrupt too much. Go ahead.
No, you don't.
I do, actually,
I
but-
know you care about these cases very much, so I understand that.
No, I appreciate that.
The mother hadn't participated for 16 months, and she was getting information from the GAL, from her DCF social worker. The court understood that the mother had reached out to the clerk's office to find out about the hearing. She did come, so mother knew, based on the facts that we know, that she needed to go to court to get her indigency reestablished.
So why is that okay?
Why is what okay?
The court's hurdle put in place that she needs to go get a third indigency evaluation.
Why do you think that's a hurdle, Your Honor?
Because she has mental illness and she had been,
Okay. And she hadn't been to the court in 3 hearings, and the judge was relying on General Laws 211D 2A subsection C, which it's clear. I'll point you to it. The language clearly says that probation department and the court, I'm putting in the court, shall reassess a parent's indigency status.
let me ask you a
during the
different
case.
question. Could the judge, recognizing that her second lawyer had withdrawn and in absentia while she was in psychiatric commitment for 3 months before giving birth to another child, could the judge have appointed a new third lawyer, instructed that third lawyer to speak to her GAL, the lawyer, GAL, who was in fact in touch with her and speaking to her at that time, and said, here's, this GAL knows where she is. I've already appointed this GAL to advise you. Please go speak to your client and find out what she wants to do. Could the
Yes.
judge have done that?
Yes, certainly.
And was it an abuse of discretion not to do that?
No, because at the time of the January hearing, the judge nor anyone else knew that mother had been hospitalized. That did not come out
Once the
until-
judge learned that,
The judge learned it in March, Your Honor,
right? And so and the trial wasn't until October.
right?
So would it have been, was it an abuse of discretion for the judge to allow this train to just keep going on, knowing that the mother has been hospitalized for 3 months at that point, doesn't have a lawyer, and the GAL is reporting, yes, I'm in communication with her. In other words, the judge knows where she is. Why is that not an abuse of discretion?
I'm not sure if the judge knew I don't know when she got out of.
No. The GAL knows where she is. The judge knows that the GAL knows where she is because the GAL is reporting to the
in
judge.
March?
No, actually, I think the GAL reported that in June, I think. But the judge in April of 2024 very clearly says this woman is suffering from diminished capacity. The judge is aware of her mental health
Yes,
limitations.
the judge is certainly aware of her mental,
Right. And the GAL has been talking to her that summer, the June before the trial. So the judge at that point in the summertime knows that the GAL knows where the mother is and is communicating with her. Why shouldn't the judge at that point appoint a lawyer, say, talk to the GAL, go talk to her, find out what she wants to do?
She could have done that.
Right.
But that doesn't mean it was abuse of discretion, Your Honor, because in that June hearing, the GAL, and it's in the record, informed the court that she told the mother about what she needed to do, and she also told the court that mother was not interested in coming to court.
Well, I think it was, I'm working. She says, Mom says,
two different-
I want my daughter, my kids to, I like the plan of my kids living with my mom, the maternal grandmother.
Right.
And when she's told you need to go to court, she says, I'm busy, I'm working. But what she doesn't say is, I agree that my parental rights should be terminated. So it seems that there's still a live issue in her mind about termination of her parental rights.
A live issue in the mother's mind? Or the
Yeah.
There may have been, Your Honor, but I can see the challenge with this case for all of you and for all the parties is that we have to make a lot of presumptions and a lot of speculation because we don't know. Okay? And so we have to go on, and I'm asking this court to respectfully look at what the judge had before her and what kind of decisions she made. I don't think it's unreasonable, and it's up to you to decide this, but I don't think it's unreasonable for a trial judge who hasn't had the client come to court for 6 months to say, the court didn't say, I'm not going to give you an attorney. The court said, tell your client or tell the mother that she has to go get her agency reestablished and I'll appoint her a new attorney.
Is there anything in the record that you can point to that you're aware of that gives us some context for that? And I not to speak off record, but I was in the district court for almost 20 years, and I don't think I ever saw anybody get a 6-month reassessment on indigency, ever, in tens of thousands,
Your Honor,
maybe, of
Your
cases.
Honor, I understand what you're saying. But,
Right? Have you ever seen it?
Huh?
Have you ever seen that?
No, but you know what?
Yeah.
Honestly,
So,
with all
a
due
sense as to
respect-
what's going on, that's what I'm trying to get at. I'm not saying that the judge was
Yeah,
legally
Judge-
incorrect, but do you think there's something that points at the judge, it was a vehicle to get the mother into court, or she actually cared about the reassessment of indigency? That just doesn't...
Say your question one more
Yeah, is there something that we could, I didn't see it, I was looking for it, do we think it was just a vehicle for the judge to get the mother physically in court to get a new lawyer appointed, saying, got to go to probation, or was there actually an application of that statute that, again,
We're
Never heard of
We're
applied.
both engaging in speculation. I think we both know that. I don't
Yeah.
know the answer, but I can
Okay,
say...
that's what I'm asking, so I don't want to speculate.
All
You
right,
can
so
say it
But
now.
can I just finish my thought?
Yeah, well, your time has expired, but I have lots more questions for you,
I
so.
know, but Judge Brennan,
Sure.
you know as well as I do, that just because especially at district court, juvenile court, there's a lot of things that happen that aren't always by the book, so to
Yep.
speak. But there is, the statute does say what the statute says.
Right.
And if the judge followed the statute, that cannot be an abuse of discretion.
No, it's fair, it's a fair point.
Let me ask you this, because we were working backwards and we haven't gotten to the beginning yet, which strikes me as the harder part of this.
Yes.
A person comes in to court, the judge is sitting there.
Yep.
I don't know if the judge knows that doctors wouldn't treat her because they thought she was incompetent, but the judge hears right away from the lawyer for her, she was found incompetent in the probate and family court. You know, I think we have to do something here. I'd like to have a GAL appointed. The judge goes on to say, well, is she waiving her rights? And your client, DCF, says, I don't think she can do that. I.e., I have concluded also that she is incompetent, and therefore I don't think she can waive her rights. Does the judge not have some obligation, sua sponte or in response to the motion for GAL, to do something to figure out if this person is incompetent?
Yeah, appoint a GAL.
Okay,
'Cause-
which GAL
Well, let me-
has the authority to determine or advise the court on the competency of a parent that's before it?
I'll answer your question, but before I do, because I don't want to lose my thought, I'm getting older, they go quickly. If this court, or if the trial judge did what the mother is suggesting that the trial court did, by sua sponte, ordering a competency hearing or an evaluation, there would be another appellate issue before you today, because that'd be totally against a parent's rights, not being able to work with their attorney to see whether that was something that the mother should do based on an attorney's analysis through the support of a GAL.
So wait, you said that what the judge should do is appoint a GAL. That's what you said,
She
right?
was asked, well,
I said, my question was,
what type?
having heard all this stuff, including the DCF lawyer saying, I don't think she can waive her rights, the judge's obligation is to do what?
Say that again, Your Honor.
All right, there's a motion for GAL appointment. There's information that's been presented to the judge, not under oath, but by a lawyer.
Not a lot of information to boot, anecdotal evidence.
That she has been found incompetent, and the lawyer for DCF says, I don't think she can waive her rights. What was the judge supposed to do here?
I don't know well, first of all, I don't know what that meant that the DCF attorney said.
I think I do.
And I'm not being.
Everyone can waive their rights unless they're
Maybe
incompetent, right?
Waive your right to competency, waive your right to counsel. I don't know, because in this case, mother didn't want an attorney to begin with. I don't know the answer to that question.
Okay.
And I actually, respectfully, I don't think you do.
On
either.
the facts here, what should the judge have done? What was the proper step to take?
To appoint, to appoint a GAL as the judge did and see how things play out.
Okay, let's stop. Which kind of GAL under the guidelines?
I'm not sure about the guidelines. I think the judge followed the direction of the trial attorney.
Okay, I'm not asking that. I'm asking what the judge should do. I don't know if the guidelines are binding or not, but there are now these lettered GALs, right? It's a GAL-E, it's a GAL whatever, right? We see this now.
But the first the first lawyer very specifically requested a diminished capacity GAL. And the judge appointed.
Say that again, Mr.
The
Judge
first
Wood?
lawyer appointed to the mother clearly requested a diminished capacity GAL.
Does the record say that?
Yes.
Does the record say, where?
Well, luckily, I get to ask the questions. And second, and as a result, it's much easier on this side. The judge appointed a lawyer, the wrong kind of GAL, notwithstanding the boxes that were checked on the form. Is that a problem?
It's not a problem because
Why?
Because the judge initially, if I remember correctly, and I want to make sure I always try to say exactly what the facts are. I don't know for certain, but I think the record reflects that the judge appointed an advisor.
Advisors are only for children, so that must be a mistake,
So
right?
that must have been a mistake.
And the second box that the judge checked was diminished capacity. Both were checked on the very first order.
Ron,
And a diminished capacity one has to be a mental health professional, right?
in January, when the trial attorney, before, I believe this is correct, you can check the record, before the attorney withdrew, or the court
A different judge eliminates the diminished capacity one, leaving only the one for children.
Based on what the trial attorney said.
Leaving.
The trial attorney recommended that the diminished capacity should be, that status should be.
Okay, it's fine,
It's a
but.
circular argument, is it
No,
not?
it's not, because a lawyer can suggest lots of things that are unlawful. The judge can't do them. And appointing an advisor, which is a GAL for children, for these parents, is not lawful, in my view.
Okay.
As a practical matter, if we send this back, in your travels in the juvenile court, are you aware of a pool of mental health professionals that might be available to act as GAL for diminished capacity? So when we send it back and tell the judge to do that, does that exist?
I have not practiced in for many years. I believe there's some way to address that issue, but before I start.
So the answer
I think that's why the
Sorry,
judge,
I just
is
wanna
it
hear
a
the
yes?
an-
Because
is
that's
the
why the
answer
judge
yes?
went to the lawyer, I think.
Say that.
It sounded like your answer to Justice Brennan's excellent question was yes, there is a pool of mental health
I'm not
professionals?
certain.
Okay,
I'm not,
all right.
I believe that, I'm not,
Okay.
you know what, to be accurate, I'm not certain.
Okay.
But before I stop, just to clarify, Judge Rubin, you know what, it's probably clear, the record is very clear that the whole idea about what type of GAL to identify is all over the place. I agree with you.
Okay.
Part of that struggle is because after January, there was no attorney. And attorneys,
And you think that's something that can be waived without the presence, you can withdraw without the presence of the client?
say that again?
You think that the judge is allowed to accept this withdrawal motion without asking the client what's going on?
For the withdrawals counsel in January?
Yes.
Based on what the judge heard from the attorney, I think she did it. I don't know. I'm not sure if it was the right decision. I'm not sure.
Okay.
But I think she heard enough information. She knew the case. She knew the mother. This was the second attorney that had stepped away because of lack of communication. Would it have been better if the judge had gotten I don't know if it was an actual motion, but mother wasn't available. So what's the court to do?
Which way does that cut in terms of allowing withdrawal of counsel? I mean, you might say, well, I got to wait till she can come in. I have no idea what's going on here. Maybe. But all right, I know that we've gone more than 10 minutes over, so we're going to have to stop. I don't want you to feel like we're beating up on you at all.
No.
You do an incredibly valuable job for us whenever you argue, because you give us information that we really need to decide these cases. And I know you've got 3 aggressive judges on your panel, and I'm sure it's difficult.
I enjoy the
Prefer
process.
inquisitive, Justice Rubin.
Yes.
But but we really do appreciate what you do. We know you have a client and are representing them, and so on. So thank you very much.
You're welcome. And in closing, the department relies on its brief, and there was no abuse of discretion in this case.
Thank you. We'll hear now from you, Attorney Goldberg, and if you want more time, you can have it too.
Good afternoon. May it please the court. My name is Lane Goldberg, and I represent the child. And I want to bring light to the child to this panel. We haven't talked much about the child, and focus this panel on the child's best interests. So the trial court was correct that mother is unfit. And all 3 of you have touched upon this, that the best interests of the child should.
Sorry, mother made the determination, the court made, sorry, but I hate to jump on you. The court made the determination that the mother was unfit at the October trial, right?
Yes.
Right. When mother wasn't there and she didn't have a lawyer, right?
When mother wasn't there, but there were there was a record
I'm just
before
making,
the judge.
I'm addressing the elephant in the room. You're starting with a finding that was, from my point of view, seriously questionable because of a major procedural problem. Mother wasn't there, and she didn't have a lawyer representing her interests at the time the judge was making that finding. That's right?
You are correct in
Okay.
stating that, but the evidence before her was that she's unfit. And it's, remanding this case, doing what mom is asking is really just delaying the inevitable here, because you're going to go back to the trial court.
If no trial had been held, we would send it back, and that too might delay the inevitable. I don't know what would happen if, when there's no trial. We see lots of cases where many cases where unfitness is not, you read the facts and it's just, it's never going to be not found on remand. But if something is, procedurally incorrect, depending how gravely incorrect, we do sometimes just have to send it back. We can't be, I understand there's this prejudice idea, but,
I would point this court to adoption of Willow that provides that the rights of the child to a stable and safe environment assume an importance at least equal to the parent's constitutional interests.
We don't let the government just pluck people away, even if the rights to stability are obviously going to be ultimately found served by termination. We have this as a parent and a child, and we kind of have to cross every T and dot every I before termination of their rights, even if it seems to me. I mean, we get your argument. I understand the argument about prejudice, but it depends on if we find errors and what they are. Obviously, there's some errors where prejudice would be a part of the calculus, but there are some that are, not really fixable, by reaching that conclusion.
I think that I don't think that there were errors that would rise to the level of sending this back. So with regard to to Mother's argument with regard to a purported constructive denial of counsel, I think the timeline is very important here, and keeping in mind that this case is very similar to care and protection of Marino, where father participated kind of early on in the initial stages of the care and protection proceeding, but then didn't participate in any other hearings, and the court said that it was an absolute abandonment of the case.
Was, in Marino, I'm sorry, was there any question of the father's diminished capacity or mental illness?
No, it was a very short rescript decision, so there wasn't.
So that seems like an important difference. The
Um,
judge here, not only was there a question, the judge was, as early as April of 2024, on the record, very clearly said, mother here obviously has diminished capacity.
Based on what, though? There were no facts before. I mean, you have to look at also, she did write, the case was filed April 5th, 2023. She immediately filed a motion. She had the wherewithal to file a motion to represent herself.
Do you know why that was denied?
I don't know.
But
It's denied.
and also, though, that to me cuts both ways, because it says, okay, this mother is not somebody who's necessarily completely incompetent, incapacitated, never going to be able to participate. And indeed, the record makes clear, DCF concedes, that over the last phase of this case, before the trial, the mother started to show some improvement. The point is that if she had the wherewithal to do some of these things, perhaps with a lawyer and a GAL to help create accommodations, a properly trained GAL with mental health capacity, it's not an academic question that the mother might have been able to avoid termination of her parental rights at a trial where she's actually got a defense.
So 2 points on that. The information about the GAL not being qualified, it's outside of the record, and that was a motion that mother had filed.
He's a lawyer, sorry, I respectfully disagree. We know that the GAL requested was a mental health professional, it's in the guidelines. We know that the lawyer that the GAL actually appointed was a lawyer. We know these things from the
A lawyer
record.
could also be a mental health professional.
Sorry.
And that
From your
wasn't before
perspective,
the court.
are the guidelines binding or are they suggestive, if you will?
A very good question, Justice Brennan. I would think that they're guidelines. I mean, they're suggested. They're not statutes.
So that just because they say a mental health professional doesn't necessarily require the judge to appoint a mental health professional as a
It's a guideline,
GAL?
it's a suggested.
But when the order itself checks a box that says diminished capacity, surely that has to be read as a reference to the diminished capacity type of guardian ad litem in the guidelines. That's why there's a box.
Yes.
Now, maybe he could have written, or she could have written, I don't know who the judge was, I'm deliberately not appointing a mental health professional because it's my idea of what this is X. I mean, maybe the judge has that, broad authority, but they checked the box, diminished capacity on a form that's printed to comply with these guidelines.
All we have is the record before us and what she actually did do. And she did check, different boxes at different times during the case. I'm not.
You agree that legal advisors for children, right?
Yes.
I mean, my head explodes, like, what, you know? I mean, I understand people
But I
didn't
have seen
understand
it,
this,
you know,
but,
outside of the record, I've seen it in my practice that there are GALs that are appointed to parents that, you know, help an attorney along with a parent with.
well,
dementia.
maybe instead of doing that in your practice here going forward, they'll do it according to law.
Yes, and I think that it has to do with the court's resources, you know, all of
Okay,
those things come into
I
play.
am sure it has to do with all those things, but I didn't write the rules here. I didn't write the
Yes.
guidelines. I don't know.
Is your bottom line on this that the mother abandoned the case? Is that where it comes down to for you? So
Absolutely.
regardless of the mistakes that were made, if they were made, or the missteps legally, if they were missteps, that the mother effectively, almost from the outset, abandoned this and therefore nothing else matters?
She did not show up to her temporary custody hearing. She knew to be there. She abandoned the proceedings after that. She didn't just abandon this proceeding. There's information in the record that says in a separate proceeding, and this was on June 14th, 2023, transcript 5, mom refused to work with either the attorney or the guardian ad litem in that case.
So what do you
At
do with the fact that she showed up in Holyoke the day before the trial?
Well, at the trial, on that day, the judge makes a note that in the youngest child's case, she hadn't been there in 200 days.
Sorry, let
She
me
hasn't
try,
shown
let me
up.
ask my question again.
Sorry.
What do you make of the fact that she showed up in court for her termination trial the day before?
I make of the fact that she was told by many, many people to go there. I don't know if she meant what she was doing there, what she was.
Sorry.
You know,
Your answer is she might not have realized it was a termination trial?
I don't know if she realized that it was a termination
Well,
trial.
she might be
didn't.
incompetent, though, right? I mean, right? You're like, she abandoned this, she abandoned that, and maybe she did, or maybe she lacks the capacity, you know, I don't know.
And all of this has to do with what I said at the beginning, is that this is, you know, further intervention into this family's life it's disruptive, and on balance, the best interests of my client have to be taken.
Is the
into account.
child still in the placement that they were in
Yes.
at the time?
Yes, the child is with maternal grandmother. She's been there since December of 2023.
Is that a pre-adoptive placement or no? Or guardianship, or what do we?
It's a pre-adoptive placement. I mean, I can go outside of the record, but in terms of what DCF's plan was, it was an adoption. I know that maternal grandmother has guardianship of the oldest child, and youngest child is also placed there.
Is the plan still adoption, or has something changed about that?
So the plan with DCF, I'm not certain of, but maternal grandmother, the plan, she wants to be the guardian.
How old is the child? She wants to be
Child-
guardian, not an adoptive.
Yes, because she has guardianship of the oldest child. The child right now is about 2.5 years old. At the time of trial, she was 1.5 years old. And so she lives with both of her sisters, both of mom's other kids, with maternal.
Have you
grandmother.
seen your client, like,
Yes.
face-to-face?
Yes, twice.
Recently, or?
I saw her, so this case was scheduled, I think, originally on November 14th, so the Sunday before that, November 9th, I saw her. If there are no
You've only gotten an extra 2 minutes and 49 seconds, Counselor, but I think I don't see any further questions.
I appreciate it. Thank you.
Thank you very much. The case is submitted. I'd like to thank the court officer and the court staff for their assistance, and the court stands in recess.